A very good morning to all present. It is an honor and extreme pleasure to welcome Mr. Rajiv Rambhatla to our campus today. Sir is a partner at Luthra and Luthra Law Offices, Hyderabad, and we will be delighted today, I'm sure, to hear Sir give us his insights about his journey and also about a topic which is not very well known. Commercial Courts Act is a typically a theoretical legislation, so it will only be an honor to learn about the practical implications of the Act. Without further ado, I request our faculty chairperson, Dr. Praveen Kumar, to felicitate Mr. Rajiv Rambhatla. Before we formally begin with the lecture today, I request everybody to please stand for the Kulgeet.
Yoga. योगः करं सुकौशलम् योगः करं सुकौशलम् हिमाचल प्रदेश राष्ट्र विधि विश्व गुरु बनना है क्यों न गुरूर करें हिमालय से ऊंचा मस्तक जिसका दूरदर्शिता आसमान की परतें चिरे हवाएं झूम झूम नाम ले जिसका बर्फ कोमलता में दृढ़ता भरे देवित्य विधि के हर विधान की मस्तक झुके कर वेदी है संविधान की त्यार करे शक्ति शासन के प्राण की और अपने भारत देश महान की तथ्य से अवगत करा तत्व अंगीकृत कराए तर्क को अंगीभूत करा वितर्क की पूर्ण आहुति डलवाए कहता है हर युवा यहाँ लेखनी और वाणी वीर बने कानूनी मदद का दरिया बहा वाद विवाद प्रतिद्वंदी बने इनके आंचल से चुरा सफेदी चलाओ न्यायालय संस्कारों से मिटाए अन्याय श्वेत श्याम वर्दी ख्याति बढ़े देव भूमि की जिससे न्याय की देवी गुरूर करें।
Thank you so much. It is my absolute honor to introduce you to Himachal Pradesh National University, HPNLU, a prestigious institution that stands at the forefront of legal education in India. Established in 2016 with the vision of fostering academic excellence and cultivating future leaders in the legal profession, HPNLU offers a dynamic and rigorous learning environment. Located in the state of Himachal Pradesh, the university blends natural beauty with intellectual rigor, providing students with a unique atmosphere for both personal as well as academic growth. HPNLU is committed to offering world class education in law, nurturing critical thinking, ethical values, and a deep sense of justice. The placement assistance cell of HPNLU seeks to act as a bridge between the industry and the students. We are blessed to have a dedicated and committed team of faculty as well as student members. Thank you so much. Good morning, everyone. It is my pleasure to introduce our distinguished guest, Mr. Rajiv Ram Bhatla. He is a highly respected advocate specializing in commercial and consumer litigation, arbitration, company law, and regulatory matters. With extensive experience in handling cases, he is the go to counsel for multinational corporations navigating legal challenges in India and beyond. His expertise spans a broad range of clients, including institutions, private equity funds, PSUs, banks, and multinational companies, as well as several prominent Indian companies engaged in high profile commercial disputes. Today, we will have the honor of hearing Sir speak on an overview of the Commercial Codes Act. This is an invaluable opportunity as understanding commercial litigation and dispute resolution processes is crucial for students preparing for careers in law and business. Gaining insights from an industry expert provides real world perspectives on the legal mechanisms that facilitate fair and efficient business practices, sharpening students' analytical skills and helping them develop a strong foundation for future success in the legal field. Sir, we are truly honored to have you here today with us and share your insights with all of us. Thank you.
Without further ado, sir, you have the floor.
Good morning, everyone. First of all, I'm very happy to be here, and it's an absolute pleasure to be here in this venerable institution in presence of all of you. And it's very nice to see all these bright faces early in the morning, and very, very glad to be here. This is, as I was telling Sir as well, this is indeed my first time in Shimla and my first time at your university as well. Very glad to be here and just soaking in all the views and the amazing weather that this place has to offer. Great. So with that background, I'd love to start off and talk to you guys about today's topic. But before that, I'll just quickly give you an introduction about me in case some of you haven't heard about me. So my name is Rajiv Ramgatla. I am a partner with Luthra and Luthra Law Offices in India. I sit out of the firm's Hyderabad office and I specialize in commercial disputes, arbitration, and I also dabble with some amount of real estate transactions. So primarily as a litigator, that's what I like to call myself. I handle a wide range of commercial and contractual disputes, right from consumer litigation all the way to contractual disputes, all the way to commercial disputes in specialized commercial courts, which were established in 2015. We'll come to that. And also insolvency and other such issues before the NCLTs and such courts. And I also appear before the high courts and even the Supreme Court as well. So that's basically about me and my practice. What I'll do is I'll go through the entire presentation. I also have one more presentation which talks about the interplay between the Commercial Courts Act and the CPC and the overlap of the procedures therein, and basically talks about which takes precedence where and how the CPC plays out in the grand scheme of things, right? So we will come to that. But if at any point of time you guys have any questions, feel free to stop me and answer, and I'll try to make this as interactive as possible and try to keep it, as inclusive for you guys as well. And we'll also have some time for questions at the end of the session. Great. So with that, we'll start off. But before we start, once you guys settle down, if I may just ask all of you, how many of you are interested in pursuing a career in litigation or in disputes? Okay, great. So that's a fair chunk. That's very refreshing to see. I was telling some of the students I was interacting with this morning as well that generally wherever you go, myself included when I was a law student, most law students want to do corporate law and are more enamored by corporate law and M&A and transactions, even though at that point you really don't understand what that means, right? But it's really nice and refreshing to see all of you interested in litigation and in courtroom practices as opposed to corporate law. That's very refreshing. Great. So I'm glad that I have so many future litigators here. So I think this session would make a lot more sense, and I'm looking forward to maybe asking you guys a few questions as this goes along and seeing your perspective on this as well. Okay. So commercial disputes, right? I mean, basically, what is a dispute? A dispute is any disagreement or any difference that arises between two or more parties, right? Commercial dispute is nothing but a dispute which arises in a commercial transaction or in a commercial setting. So, let's say if there are two parties, one of whom is a business entity or both of which are business entities, and they have a relationship or a transaction for a particular business, and then a dispute arises in that transaction, that would be termed as a commercial dispute. So simply put, a commercial dispute is any dispute that arises between either one business entity and another entity, or between two or more business entities, right? So commercial disputes are common in the business world. In India, the Commercial Courts Act 2015 was passed to ensure speedy resolution of commercial disputes, and the Act essentially provides businesses with a faster and more efficient way of resolving disputes. Now, if you look at the history of litigation in India, typically all civil disputes were categorized into civil courts, and there was no separate segregation or categorization of commercial courts or commercial disputes before the Act was implemented in 2015. Right? तो इसके पहले क्या होता था कि all the disputes would go before the civil court, and it was very common for some of these disputes, although civil in nature, to take a very long period of time for resolution. For some of these disputes to be embroiled in the courts for almost years together. This was really impacting India's ease of business standards, and this was really impacting how businesses across the world viewed India as a potential place of business and as a potential place of foreign direct investment, right? Essentially, around 2015, when we had the whole paradigm shift of India happening towards Make in India and towards a lot of investor friendly and business friendly initiatives. This was also one of the initiatives that the then government thought of implementing to bring about speedier, I would say, resolution of commercial disputes, right? That was essentially the intent behind implementation of this act. So, what are commercial disputes? We were just talking about what commercial disputes are. So we will look into the definition of commercial disputes, not as per what I just told you, but as per the Commercial Courts Act as well. We will also look into examples of commercial disputes, the importance of resolving commercial disputes, and of course, the Commercial Courts Act itself. So, starting off with an overview of the Commercial Courts Act. The Commercial Courts Act is a legislation that was passed by the Indian Parliament to provide for speedy resolution of commercial disputes. I've already mentioned this. It came into effect in October 2015, and it replaced the erstwhile Commercial Division and Commercial Appellate Division of High Court's Ordinance of 2015. So, this ordinance was the one that actually set commercial courts into play, and then this was formally replaced with the act that was passed in 2015. Now, commercial courts also come with a corresponding appellate jurisdiction of the high courts. We will come to that and I will explain what that means. Till this point, any questions? I hope it's all clear. Great. At any point, if you guys don't understand, please feel free to stop and ask me. No issues at all. Perfect. Okay. So coming to definitions under the Commercial Courts Act. So Commercial Courts Act, like various other legislations. Okay. Before we come here, you guys would have come across quite a few legislations by now. Typically, in most legislations or most acts, which is the provision that talks about the definitions or in that particular act. Right? Section 2, right? Generally, in most of your acts, Section 2 would be the definitions section, which carries the definitions of the various terms that would be used in that particular act. Right, so Commercial Courts Act is no different. Section 2, various subclauses of Section 2 of the Commercial Courts Act provide for the definitions. Section 2 is the definitions clause. So if you look at Section 2C, that defines what a what a commercial dispute is, right? So Section 2C is one of the most important provisions because that actually tells you whether a particular dispute that you have is something that can be tried before the commercial court or not. Now, if you look at Section 2C, it has about 35 or 36 subcategories of disputes or contracts which fall under the definition of a commercial dispute. So, if there is a contract of that nature, that would be classified as a commercial dispute. There are about 35, 36. Okay, you guys can have a look at the provision today. It's available online. It's available on the Government of India's website as well. You can check out the provision and in fact have a look at the act as well for yourself. Now, one of the next most important aspects of the Commercial Courts Act is specified value, which is Section 2D. How many of you understand the term pecuniary jurisdiction? Anyone? Okay, does anyone want to just take, just want to explain? You please.
Well, the jurisdiction that a court exercises depending on the amount of money.
Exactly. Perfect. Thank you so much. So yeah, that's exactly it, right? So any jurisdiction that a court exercises depending on a particular amount or a particular threshold of money means pecuniary jurisdiction, and that's exactly what specified value here means. Specified value means any dispute, for a dispute to be classified as a commercial dispute, it would need to be of a specified value. As per the Commercial Courts Act in 2015, the specified value for a dispute to be classified as a commercial dispute over and above classifying as a commercial dispute under Section 2C. So if it falls under those 35 categories of contracts, it also has to fall under the specified value, which back then was a minimum of 1 crore rupees, right? 1 crore was initially the threshold for a commercial dispute under the Commercial Courts Act under Section 2D. However, this was later amended and brought down to 3 lakh rupees in most states. This notification hasn't been notified in quite a few states, but it has been notified in most states. Right? For example, Karnataka was one of the first states to implement this amendment. And in fact, it's one of the first states to implement commercial courts in full swing. In fact, if you go to Bangalore, I don't know how many of you have had a chance to visit courts in Bangalore. But if you go to Bangalore, you will see next to the city civil court an entire building just for commercial courts. Okay, there is a full building in Bangalore which is dedicated to commercial courts, and there are about 10 court halls in Bangalore alone for commercial courts because they have already notified this provision, and because the value for a commercial dispute has been brought down from 1 crore to 3 lakhs. A lot of disputes are being numbered as commercial disputes, and the advantage of this we will see in the coming slides. Section 2E defines what a commercial transaction is. Section 2F defines what commercial division is, and Section 2G defines what commercial appellate division is. Okay. So essentially, commercial division is nothing but what the commercial court is. So when a commercial court is said to be exercising its jurisdiction, it's doing so in the commercial division of a civil court, right? So commercial courts are generally categorized as separate courts within the premises of a city civil court. So you will have it in the premises of any other city civil court in any city you go to. For example, in Hyderabad, the city where I'm based, the commercial court is within the city civil court premises and it is on the second floor. The 24th ADJ court, which is a regular civil court, also doubles as the commercial court in Hyderabad. Okay. Commercial appellate division, on the other hand, is basically every high court where there are commercial courts also has, along with the regular appellate division, a commercial appellate division, which is essentially the division to which appeals from the commercial courts go. So let's say if you have a commercial court in particular state, I was just giving you the example of Karnataka and Hyderabad. So let's say there is a dispute that is settled before the commercial court. The commercial court passes an order in, say, Hyderabad. The High Court of Telangana in Hyderabad has the commercial appellate division. So if one of the parties is aggrieved with that decision of the commercial court, they can file an appeal before the commercial appellate division of that particular High Court, which in this case is the Telangana High Court. So that's basically commercial division and commercial appellate division. Jurisdiction of commercial courts. So Section 4 of the Commercial Courts Act deals with the jurisdiction. Commercial courts have jurisdiction over disputes with a specified value, as I was saying. 1 crore was initially a specified value. In some states, even now the specified value is 1 crore because the amendment has not been notified. For example, in Hyderabad, even now the specified value of a commercial dispute is 1 crore. Commercial suits are tried as commercial suits only if they meet the specified value of 1 crore. But for example, in other states like Andhra Pradesh or Karnataka or even Tamil Nadu, this amendment has been notified and any dispute over 3 lakhs can be classified as a commercial dispute there. The commercial courts also have jurisdiction over disputes that relate to intellectual property rights, international trade, and other specified areas. Cases related to specified areas can be designated as commercial disputes at any time by the central government. Now, as I was saying, Section 2C has about 35, 36 different categories. So, a dispute of the IPR nature or which is of the international trade nature can also fall under those 35 categories mentioned there. And if it does, and if it meets the specified value, then that particular dispute also will be tried as a commercial dispute. One more interesting thing that you guys might want to know is that while the specified value for the commercial division is 1 crore, there is also a possibility where a particular case could be filed, commercial dispute could be filed directly with the commercial appellate division of the High Court, which in that case becomes commercial original division. If there is a particular specified value, any idea? Does anyone know what is the specified value for a dispute to go directly before the commercial division of the High Court? Anyone? So, okay, specified value for a commercial court is 1 crore, but if a dispute is over 10 crores, it goes directly before the High Court, before the commercial division of the High Court. So, if a commercial dispute is above the value of 10 crores, it directly goes before the commercial division of the High Court and not before the regular civil commercial court. Now, the Act also allows for transfer of cases from other courts to commercial courts if they meet the specified criteria. This happened especially in 2015-16 when the Act was implemented for the first time. A lot of the cases which would have been commercial cases if the Act had existed when they were filed, which were being tried as regular civil suits, were actually transferred to the commercial courts because they met all of the criteria and all of the eligibility requirements for a commercial dispute and they could have been tried before commercial court. So all these cases were actually transferred. They were closed in their respective civil courts and they were transferred with fresh filing numbers to the commercial court. I'll come to the benefits of this and the benefits of commercial courts in just a second. So establishment of commercial courts. Some of the key features of commercial courts in India are as follows. So, of course, mentioned that commercial courts are established at a district level. Section 3 is, of course, one provides for the commercial courts at a district level. Essentially provide for speedy resolution of commercial disputes. And then the high courts, of course, have the appellate divisions. This is under section 3(2) of the Act. And the central government has notified areas for establishment of commercial courts. Again, the section 3 is, of course, 3 of the Act. Okay. So, what is the need for speedy resolution of commercial disputes? Now, one is, of course, the timely resolution of commercial disputes is crucial for business. You might, how many of you have interned with companies or with in-house teams of companies so far? Anyone? Okay, how many of you have interned with law firms? Okay, or with say individual practitioners? Okay, perfect. So you might have come across corporate clients or companies which are clients of either the law firm or of the practitioner, right? So you will understand how crucial the closing of a particular dispute is for them. Most of the times you will see the in-house counsel of the company would interact with you or with your senior, would ask about how soon the matter would be closed or if there's any possibility of settlement of that matter, or if there's any other way in which that matter would be closed. So companies have certain criteria, especially in-house counsel have certain criteria based on which they are assessed. And one of the criteria is how effectively they're handling disputes. And the managements typically measure them and their performance. In fact, even their annual performance and their appraisals are sometimes linked to how well they are able to have disputes closed and how well they're able to manage the existing litigation for the company. That is one aspect. From another perspective, from the operations perspective of the company, also it becomes very crucial for the disputes to be settled in a timely manner. For example, let's say a company has entered into a contract for supply of certain goods with another company, and due to a dispute with that particular vendor or with that particular counterparty, the business of that company with other suppliers or with other vendors is also being affected because they might feel like because this company has filed against this particular vendor, they might feel like this is a litigious company and they might be filing cases against them as well. And that might affect that company's chances of business in the long run as long as the dispute continues and the dispute prolongs. So it's important from that company's perspective to ensure that in the anticipation of future business to ensure that the disputes are closed at the earliest. So from that perspective, timely resolution of commercial disputes is extremely crucial for business. Now, delays in resolving disputes can lead to long-standing conflicts, loss of revenue, and damage to business reputation. Now, this is what I was trying to say. Now, if there are disputes that are going on for a long time, then that sort of puts a bad reputation about the company in the market, especially if there are a number of companies. Then generally the reputation, there are a number of disputes of one particular company, then the reputation of that particular company would be that this is a litigious company and they just keep filing frivolous cases against people, and over a period of time, other companies would stop doing business with that particular company, and it affects their business reputation. It eventually leads to a loss of revenue as well, right? So it's very important from that perspective for disputes to be wrapped up very, very quickly. Now, this is an interesting fact. In 2016, so in subordinate courts, about 3.7 million cases were pending. Right? Does anybody know how severe the problem of pendency of cases is in India? So, I was reading a couple of years ago, and I'm not sure of the latest statistic, but I believe in India, for every one judge, we have about close to a population of 5 lakh people for each judge, which to me sounds excessively disproportionate, right? I mean, it's extremely disproportionate, and it's a very sad state of affairs that we have for a country that has such good infrastructure and such a huge population. For us to not be able to have sufficient number of judges or sufficient number of courts seems to be really surprising, and I think that is one of the reasons why there is such a huge pendency of disputes, and it was from this perspective that the Commercial Courts Act was implemented to basically address the issue of pendency and to address the speedier resolution of commercial disputes. Now, the Commercial Courts Act 2015 aims to address this backlog and provide speedy resolution of commercial disputes. The quick resolution of disputes allows businesses to focus on their core operations. Now, at the end of the day, for any company, they're not there to participate in disputes, they're not there to go to courts, or they're not there to invest their time in litigation, right? At the end of the day, a company's goal or a company's core area is its business operations for it to do what it does best. That is, it could be operations, it could be manufacturing, could be anything that the company does, provision of services. Now, if the company is occupied with disputes, then it gives that particular company less time to focus on its core area. Now, quick resolution of disputes basically allows that business to focus on its core operations, right? Great. So, our Commercial Courts Act also provides for a fast track procedure under Section 16 of the Act. This procedure is applicable to cases where the specified value of the subject matter is at least 3 lakhs and less than 1 crore. This is something we discussed, that is basically the pecuniary jurisdiction of the specified value for a commercial dispute. Now, the fast track procedure is designed to be quicker than the regular court proceedings, and it's quicker than the regular commercial court proceedings as well. I'll just come to the timelines under the Commercial Courts Act. And for a fast track procedure, the timeline is 6 months for disposal of the case. Now, has anybody heard of the concept of a summary suit? Right? If you guys have heard of a summary suit under CPC, right? So CPC also provides for a summary suit where generally, if the other party is not appearing or if there is a possibility of an ex parte hearing, provides for a matter to be heard in a summary manner. And the timeline for a summary suit is also 6 months. So this is sort of similar to the same timeline that we have for summary suits under CPC. The types of cases that can be resolved through the fast track procedure include cases where the parties agree to use the fast track procedure. Typically, most commercial disputes can be addressed or resolved through the fast track procedure, but it depends on both the parties agreeing to use the fast track procedure. So if your respondent is not agreeing for the fast track procedure, then you will have to go through the regular procedure of the commercial courts. Now, features of the Commercial Courts Act. The Commercial Courts Act 2015 is a significant legislation, and it has some key features such as specialized commercial courts, we just discussed that, and the specialized appellate division as well in the High Court, constitution of appellate courts, constitution of the regular district courts as well, that is commercial courts in the district, definition of commercial courts, timely disposal of the disputes, use of ADR mechanisms. Okay, this is something that is interesting. This is where I would like to speak about some of the key features of the Commercial Courts Act. How many of you have heard of the types of ADRs or are aware of the different types of alternative dispute resolution mechanisms? Anyone? Can anyone name a couple of ADR mechanisms? Okay. Right. The most common ones are arbitration, mediation, and conciliation, right? So, the Commercial Courts Act does something very interesting in terms of attempting to merge mediation with the possibility of a commercial dispute. Right? It does so by something called as Section 12A of the Commercial Courts Act, which is essentially the provision that provides for mandatory pre-institution mediation, or PIM as it is called. Now, what this means is that before a party initiates or files a commercial suit, assuming that it meets all the other criteria under Section 2C and the specified value and all of that, before the commercial suit is filed, there is actually a mediation process that takes place, and this mediation is known as the mandatory pre-institution mediation. Okay, so until unless this mediation process is done, the commercial suit cannot be numbered. There is a process, if it is a very urgent dispute, there is a process to waive this requirement as well, but we'll come to that later. Essentially, what happens is, if you're a party, if you're a lawyer filing a commercial suit on behalf of your client, when you approach the commercial court for filing a suit, they will direct you to something known as the DLSA, which is the District Legal Services Authority, to first file an application for mediation under Section 12A of the Commercial Courts Act. You will file that mediation application, pay a small mediation fee, and essentially what happens thereafter is that there is a mini mediation proceedings which starts before the DLSA. Now, what the DLSA does is they have mediators appointed, they will send notices to the respondent to come and first try and settle this dispute through mediation before a commercial suit is registered. Right? Now, the respondent has two options, either to appear and participate in the mediation proceedings, and if the mediation proceedings are successful, then good, the issue is resolved. If the mediation proceedings fail, then a commercial suit is registered. Right? That is scenario one. Scenario two, which is what happens most of the times as well in the practical scenario, is that the notice is sent and respondent doesn't appear. There are three opportunities or three hearings given for the respondent to appear. So first date, respondent doesn't appear. Second date, nobody appears. Third date as well, nobody appears. So then what the DLSA does is they issue something called as a non-starter report. So they say that the mediation has failed because the respondent, in fact, they say that the mediation has failed to even start because the respondent did not appear. And on that basis, they provide a non-starter report. And basis that non-starter report, you go back to your commercial court registry and they register your commercial dispute based on the non-starter report being issued. So for your commercial dispute to be registered, it's very important to have the mediation. It is in fact mandatory to have the mediation proceeding on a Section 5A done. Either you have a mediation conducted or you get a non-starter report for non-appearance of the opposite party, consecutive non-appearance, 3 non-appearances. You get a report, and then basis that report, you file uh, before the registry and get your dispute registered and numbered. Right? That's essentially the procedure. This is one of the, I think, distinguishing factors which is not there in CPC or any other procedural law that deals with disputes. Right? This is for the first time that mediation is almost being mandated and enforced, which is sort of, if you think about it, against the very definition of mediation, which is supposed to be voluntary by nature. One more interesting, I would say, provision or rather feature of the Commercial Courts Act is that it provides for a timeline for the dispute. Commercial Courts Act basically provides that commercial disputes have to be wound up within 2 years of their institution. They provide for the requirement of a case management status, which means that after every hearing, the proceedings of the day have to mandatorily be uploaded online. The update or the order, daily order, has to mandatorily be uploaded online, and basically a case management, that is, there are under the Commercial Courts Act, there are provisions given to basically monitor the progress of the case, right? So within 60 days of the suit being filed, you have to file your respondent has to file their counter. Within 30 days therefrom, a rejoinder has to be filed. Then there's a timeline given for the evidence of both the parties to be read as well. And then eventually, within 2 years, the entire case has to be heard and awarded or ordered on. The order has to be passed within 2 years, not the hearings being completed. Because a lot of times we've seen in commercial courts that arguments are completed, but the judges are just giving dates for the orders because the judge is either pending retirement or pending transfer, and he just doesn't want to take the responsibility of writing the order. So within 2 years, the order has to be passed. That is what the Act mandates. Use of alternative dispute resolution mechanisms, we just saw that. Appointment of technical experts, power to impose costs for frivolous claims. How many of you have come across the court's power to impose costs? Is anyone aware of this? Yeah, actually, you want to give us an example?
Sir, I did an internship. Sir, I did an internship in MP Arbitration Tribunal, and there is no process of judges. They are called members, and they apply cost on parties who do not come to courts regularly and do not hear the proceedings and attend the proceedings.
Right, exactly. You had an example?
Yes, sir. A similar thing in the debt recovery tribunal at Hyderabad itself.
Oh.
There was no, whenever the party was absent multiple times, costs were imposed. Albeit they were just 1,000 or 2,000 rupees.
Exactly. Perfect. Yeah, exactly. So that's the example. So whenever there is a frivolous claim made or the party doesn't appear or waste the other side's time, especially given that the Commercial Courts Act is a time-bound procedure. For example, both the Arbitration Tribunal and DRT don't have a time-bound procedure. Yet, since the time of the other party is important, a lot of time the courts tend to impose costs on the parties that try to deliberately waste the court's time. So sometimes you will see that if a party has to file a counter or a rejoinder, they will unnecessarily keep taking dates, right? So the lawyers sometimes tactfully want to just take time in order to, just upset the other side's strategy, because the other side would come prepared for arguments. You will just go and say, no, my lord, I'm not ready, just give me some time. And the other side's entire strategy or preparation of arguments, sort of goes waste for that day. So a lot of times courts take this seriously and they impose costs for awarding time. Or sometimes they impose cost and they say that no, you argue today. They will impose a cost, but they will say, no matter what, at least if you're not arguing, I'll hear the other side today. That also happens where courts tend to do that in order to be fair to everyone. So it's not just in case of adjournments, but in case of a lot of frivolous claims, costs can be imposed. As the example was to generally costs are around 500,000 rupees or 2,000 rupees. But having said that, in some of the NCLTs and some of the other places, I've seen costs of even 50,000 or 1 lakh also being imposed on parties depending on their conduct and their lawyer's conduct. It happens, it's not unheard of. The right to appeal against interim orders is also an interesting feature of the Commercial Court Act. So if you're aggrieved by a particular interim order of a commercial court, you can again approach the appellate division of the High Court by way of CRP, which is a civil division petition, as you do typically under the CPC for any other order. Some of the important provisions of the Commercial Courts Act are again pretty self-explanatory, but you guys can just go through this quickly. Section 7 provides for the constitution of the specialized commercial courts that you were just discussing. Section 8 provides for the qualifications and experience of judges for commercial courts. Section 9 provides for jurisdiction of commercial courts in the commercial divisions, which is what we broadly discussed. If some of you are taking notes, again, don't bother, I'll be sharing these PPTs with you, so don't worry. You can focus on just, hearing this. Section 10 provides for establishment and jurisdiction of the commercial appellate courts. 12 provides for timely disposal of cases by commercial courts or commercial divisions. So Section 12 is the provision I was talking about, which provides for the timelines of the disputes and the timelines for the case management within which the dispute has to be resolved. Right? Section 16 provides for the power of the court to impose costs, which we were just discussing. And then, of course, Section 18 provides for the appointment of technical experts for commercial disputes. So, how many of you have heard of, in consumer matters or in civil disputes, a court commissioner being appointed? How many of you have heard of this term? Right. So, a court commissioner is nothing but a technical expert on a particular point of law. Sometimes you have consumer matters filed for, say, a deficiency of service or a deficiency of a product in, say, let's say a car, or an owner of a car would file against the automotive company for a deficiency of service or for a manufacturing defect in that car. Right now, how does the court determine whether, like for example, let's say a person is alleging that they bought a brand new Toyota car and that car has an engine leakage defect, right? It's a manufacturing defect, and that person alleges that and goes to the consumer court. Now, when that case is being heard or when that trial is happening, how does the consumer court decide whether there was an actual leakage or whether the engine was actually faulty, whether it was a manufacturing defect, whether it was something done by the consumer himself? How does the court decide that? Because court more often than not will not have the technical expertise to understand how an automotive engine runs or the science behind it. The court wouldn't really be able in a position to understand. So from that perspective, what courts do in these matters where they need technical expertise is they appoint something called as a technical expert or a court commissioner, and the court commissioner would then study the facts available and give their report. Based on that report, the court would take a decision. So typically, under the Commercial Courts Act, also you have the provision to appoint technical experts in case of any complex commercial disputes. Like for example, we were talking about IPR disputes, and there is a dispute on a particular patent to manufacture, say, a particular the process of a particular product, right? Which might be a little scientific in nature. If the court feels that it needs any technical assistance, they have the power to appoint technical experts for deciding such matters. Some more important provisions of the Commercial Courts Act. Again, we've covered most of them. These are some of the prominent judgments of pertaining to the Commercial Courts Act. So the first one, HDFC Bank Limited, which is Satpal Singh Bakshi, This is one of the Supreme Court judgments where for the first time the need for establishing a separate act for addressing commercial disputes was spoken about. So, in many ways, this judgment is considered as the genesis for the Commercial Courts Act. It's a very interesting judgment if you guys want to read it. Indus Mobile Distribution versus Data Rate Innovations was one of the first appeals that went all the way to Supreme Court from a commercial court. It is also a very interesting judgment as well. And Nilkant Township Construction Private Limited versus Urban Infrastructure Trustees is a very interesting judgment because it's an NCLT matter that eventually went to the NCLAT on appeal. And this was where the point of whether a commercial dispute which is filed in parallel to insolvency proceedings would be valid or not was addressed. So this is also a very interesting judgment. So yeah, in just summing up what we've discussed so far, Commercial Courts Act essentially brings some changes to how the commercial dispute resolution takes place in India. There are specialized commercial courts now. If most of you are not aware now, you would know in most districts, most states, these commercial courts have been notified and they are already working full-fledged. ADR mechanisms are mandated in these courts through this act to reduce burden on the courts. The court can, of course, impose costs, and the parties have the right to appeal as well. And the act basically provides a business-friendly environment in India by promoting dispute resolution efficiency. That's essentially what the act is trying to do by ensuring that that commercial disputes are time bound. Because before this, when you go for any civil dispute, there was no clarity or visibility on how long your dispute would go for. Right. So now with the Commercial Courts Act, businesses can at least be assured that a dispute would be wound up in say 2 years or a little bit more than 2 years. So yeah, that's essentially the end of the first presentation. I have one more on the interplay between CPC and Commercial Courts Act. We'll also quickly go through that. Well, if there are any questions on this so far, please. Yes.
Hello, Mr. Rajiv. My name is Piyush Pandit. I'm a final year student. We will graduate June next year. Yesterday, only coincidentally, in our ADR lecture with Dr. Rohit, we were discussing about the Section 12A on pre-institution mediation. While we were talking about the divergent jurisprudence on whether it is mandatory or not, because some courts have said that, okay, parties may not go into mediation. My question is, in a case, for example, for commercial arbitration, where pre-arbitral procedures have been given in the contract itself, do the parties have the right to waive off such a requirement once it is in the contract, or maybe when it's mandated by legislation? Because you yourself said that procedures like mediation are party driven and voluntary in nature. So can the parties waive such a requirement, one, when it's given in the contract, and second, when it's mandated by legislation, like the commercial laws?
Yeah, thanks for that. So I think your question is twofold, and you're basically talking about one, commercial arbitration proceedings, which is separate from, again, commercial court proceedings. Let me answer the arbitration part first, because I think that was the first part of the question. If anything is contract driven, and especially arbitration is completely contract driven, it is governed by the governing contract and by the arbitration contract, which is essentially the arbitration clause in that contract. Now, to simply answer the question, the answer is no. The provisions of the contract cannot be violated. It has to be, if it is, then the entire proceeding can be challenged. The procedure laid out under the contract for either the pre-arbitral procedures or if any other pre-litigation procedures have to be followed to the T, and if it is not followed, the entire arbitration itself can be challenged. So I think that answers the first part. With regard to the courts holding it mandatory or not, to the best of my knowledge, the Supreme Court in at least 3 different judgments has held that Section 12A is mandatory. Parties have to go for mediation. There is, of course, a provision provided under Section 12A itself for waiver of mediation in certain emergency situations, which is again at the discretion of the court, the commercial court itself, to allow such waiver. But then generally, Section 12A has to be followed typically across all courts. It has to be there has to be mandatory mediation. But then again, that has nothing to do with the pre-arbitral procedures or in a commercial arbitration, which is typically governed by the contract. And here, the Commercial Courts Act governs commercial disputes. So two separate things. Anyone else?
Good afternoon, sir. I am Anushka. I'm also a final year student. So I have two questions for you. A, considering that, of course, acknowledging that there's a backlog of cases in our country, do you think that just separating the courts is a step enough, or are there any further recommendations which you could say could be used for speedy justice? And the second part of my question is that although the courts, there's a time bound limit on the courts, but do you think that in order to fulfill that time bound limit, sometimes the court skips over essential, let's say, procedures just in order to fulfill the time bound limit by going through the case?
So,
Thank you.
thanks. That's a great question. So, to answer the first part of your question, yeah, I think it is important to segregate courts into various categories. I think in India we've already been doing it, and that's one of, I think, the nicer things about our judiciary, where we have the capability to address different subject matters under different codes. Like, for example, administrative disputes are dealt by the administrative tribunal, income tax or separate separate. Criminal Competition Commission handles only competition matters. Consumer forums handle, consumer-related disputes. You have labor courts. So I think the fact that these are segregated not only helps with the pendency, because different sort of disputes go under different heads. So already the pendency issue is taken care of. Otherwise, imagine if all these cases were crammed up in civil courts, it would be much more, much more complicated than it is right now. So having said that, I think it is very nice that we have separate codes, segregated codes for various subjects like we do. I'll just give you an example. I was in Singapore last year for a conference called the World Litigation Forum, and I was talking to some lawyers from Singapore. In fact, met a lot of Singaporean firms. So they were saying how they're always amazed that India has separate courts for separate subject matters, and how in Singapore they have only one civil court or one court where all of the claims go. So be it a divorce matter, be it a legal proceeding, be it a custody matter, be it a criminal matter, it all goes before the same court. Whereas in India, they are very surprised that we have segregated magistrate courts, we have civil courts, we have consumer courts, we have arbitral tribunals. So that was something that was very surprising. So even arbitration applications are filed before the same regular civil court in Singapore. So they were very surprised by the system that we have. So I think given our size and the diversity that India has, it's very important that we have these specialized courts. Because if we didn't, then it would have just been a whole mess with everything being, especially imagine family matters, criminal matters all being in the same court. It would have been very messy. Even now, it happens where one court exercises multiple functions. Like, for example, I was telling you in Hyderabad, the 24th additional district judge is also the commercial judge. And similarly, we have some judges who are magistrates. They're also civil judges, and they're also family judges. So you have the same court hall playing multiple roles sometimes. But then that segregation is important because it at some level, at some minuscule level, it helps deal with that pendency of issue, that issue of pendency which we're facing. So, now, coming to the second part of your question, so I'm so sorry. Can you just repeat the second part again?
My second question was that does it happen sometimes that in order to fulfill the time
Right,
bound,
fine.
the court skips essential procedures, or
Right.
there is some hindrance to justice?
Right. No, that's very interesting take, because court does courts actually do emphasize the procedures, but however, for the sake of timelines, procedures are not overlooked. In fact, sometimes timelines are overlooked, but procedures are not. Right? Courts, in fact, take procedures very seriously. I've seen, in fact, even on the Commercial Court Act, a lot of matters not being decided in 2 years simply because the procedures have not been followed, or simply because the case management under the Commercial Court Act has not been followed. Courts have no qualms in extending these matters beyond the 2 year limit, and they don't generally expedite, at least on the procedural front. They don't expedite it, of course, on the actual hearing front. They might expedite hearing the matter, but they don't expedite or they don't skip procedures just to ensure that the timelines are met. The courts have no qualms in fact delaying the timelines, but they do follow the procedure to the T. Any other questions? Yes.
Good morning, sir. I'm Utkarsh Chandra, a second year student from HPNLU. I wanted to ask that suppose two parties who are in a dispute had agreed to choose a law to govern the contract which is not Lex Local. Let's say the CISG. So in that case, how do the commercial courts in India accommodate that to on the contract?
Um, can you just come again with the particular law that you mentioned?
Sir, the Convention on International Sales of Goods, the
Right.
CISG.
CSD, right? So see, any international trade related or any international related point, again, ultimately in terms of procedure is governed by the Commercial Courts Act. But having said that, again, if there is a particular area of law which the court feels it needs any assistance on, it generally engages technical experts on that point. As I said, Section 18 of the Commercial Courts Act allows the courts to engage technical experts for these kind of things. So if at all they need somebody for a particular point of law, which could be like, for example, I give the example of IPR or the international trade. So if the courts feel that to interpret a particular provision of law, to interpret a particular legislation itself, or even if it's an international point of law, to interpret that if they need any help, then the court will definitely not shy away from appointing a technical expert for that purpose. Any other questions? We'll have one more Q&A round after this anyways. Hold on to your questions at the time. Great. Okay. So as I was saying, the interplay between the CPC and the Commercial Courts Act, this is slightly important because both are procedural in nature. Commercial Courts Act also essentially lays down the procedure for handling commercial disputes, whereas the CPC talks about the procedure for a civil suit, right? How many of you are aware of the CPC or have been taught CPC or I think mostly are fifth year? So have CPC has already been covered for you guys? Okay, perfect. So you know what CPC is. Okay, so coming to this Commercial Courts Act, as we saw, was enacted in 2015 to enable speedy redressal of commercial disputes. It emphasized the need to expedite disposal of high stakes commercial disputes, thereby enhance investor confidence. That was the main agenda behind the Commercial Courts Act. The legislation, which was already amended once in 2018, was the key component of the present National Democratic Alliance government strategy to improve India's ranking in the Ease of Doing Business Index. Right? So that's essentially what we were focusing on. So this was stated by the Law Minister then in one of his speeches in Parliament, where he was talking about how India's ease of doing business index is low in the world, and he wanted to bring it up. So from that perspective, Commercial Courts Act was one of the steps that was taken in that direction. The events that resulted in the 2009 Commercial Divisions Bill. So this was pending almost since 2009. We also saw the judgment that I was telling you about in 2012 that sort of led to the forming of the Act. So there was a debate on setting up of exclusive commercial courts based on the 188th report of the Law Commission of India in 2003. This was initially initiated by suo moto by the Law Commission of India, and then it did face a lot of criticism, and then eventually there were a lot of debates. Then finally, the LCI categorically advocated creation of the exclusive commercial divisions in high courts in India to save further embarrassment to the judiciary, and that's sort of what led to the forming of the Act. So there were a lot of challenges that this bill faced in 2009, but ultimately nothing happened. It was just shelved in 2009. Then this was the second wave when in 2015, the Commercial Courts Act, as you can just see, there's a flowchart that just provides for the timeline and how the background which led to forming of the Commercial Courts Act. Again, I'll share this with you so you guys will have this history accessible. So the Law Commission of India basically annexed a revised bill titled Commercial Division of Commercial Appellate Division of High Courts and Commercial Courts Bill 2015. This was almost the final bill that was passed as the Act, and they amended several provisions of the CPC and stipulated that these amended provisions will prevail over the CPC provisions. And some of the procedural amendments were as follows. So one is conducting case management hearings to set out mutually agreeable schedule to conclude the litigation process in a streamlined and time-bound manner. So Have any of you in your internships or otherwise attended any arbitration proceedings? Okay, so did you notice that the first hearing that happens in an arbitration proceeding is something that's called as a scheduling hearing, where the parties essentially schedule how the arbitration is going to go. So they fix dates along with the arbitrators for filing of the claim statement, filing of the rejoinder or the counterclaim, then filing of the evidence and the affidavits of both parties, and then framing of issues, and then the arguments. All of these dates, the scheduling is done on the first date of hearing of the arbitration itself. You guys aware of this? Yeah, so this is something that is very, very similar to that. Case management hearing is nothing but hearings that are done from time to time to fix timelines for hearing of the matter. So basically, they'll fix timelines for the date on which the since the paper already filed, the date on which the counter, which is the essentially the reply would be filed, the date on which the rejoinder would be filed, date on which evidence would be led by the parties, and then the arguments, and then eventually the order. All of this would be scheduled on in time to time case management. An upper cap of 120 days to file written statement against a plaintiff failing with the defendant will forfeit his or her right to file such a document. So under the CPC, I think it was 120 days. If I'm not wrong, under the Commercial Courts Act, it was eventually 60 days. That was decided. A new and separate process for a summary judgment, which would allow cases to be summarily adjudicated before the actual commencement of trial. This is slightly different from the summary, like the Commercial Courts Act provision, fast track procedure is slightly different from the summary judgment procedure under the CPC. Now, strict implementation of the timelines prescribed for different stages in the CPC 1908. Right? So this was also something which was amended for the Commercial Courts Act. The structure of the courts under the unamended Act 2015, and that is the structure of the courts under the Act after the 2018 amendment. So before, what happened was there was a commercial appellate division of the High Court, and appeals from the commercial court and appeals from the original civil jurisdiction High Court, which I was talking about. This was about 10 crores, which go to the original commercial civil jurisdiction of the High Court. Both the appeals would go to the commercial appellate division of the High Court. But under the amended provisions, you see that an appeal, so there is of course the district level commercial court that will go to the High Court, which is the appellate court. And then you have the commercial court at district level, and then you have the appeal before the and an appeal from the original jurisdiction to directly to the Supreme Court, and an appeal from the commercial division of the High Court to also go to the Supreme Court. This was the amended. So this was the amendment. Yeah, so this was the amended structure that was there after the 2018 amendment. Now, key amendments to the CPC under the Commercial Courts Act. Case management hearings, this is, as I was saying, one of the key differentiators from the CPC. CPC did not have the provision for a case management hearing. So, key procedural reform that espoused advocates of the Act are the provisions under Order 25A, setting down procedure for case management hearings. These hearings essentially require the judge and parties to establish a mutually agreeable schedule for smoother, more organized, and time-bound trial process. Right? It's not a novel idea. However, its introduction was inspired by a similar process in other jurisdictions. And under the Act, a court must mandatorily hold a case management hearing between the parties, which cannot be adjourned, and schedule timelines for different stages of the litigation. This is what I was explaining. Then you have the process for the summary judgment. Then also you have no appeals against an interim order. Now the Act also mandates that there will be no civil division application or petition against any interrogatory order of a commercial court, and any such grievance under the against the order, which may only be raised in appeal against the final decree. However, this was later changed, and appeals against interim orders were also allowed under the Commercial Courts Act. Of course, then pre-institution mediation was also something that was mandated after the 2018 amendment of the Commercial Courts Act. Now, this provision requires parties to attempt an out-of-court settlement of disputes before approaching the court for litigation. This is what I had explained in detail. Now, the idea of pre-institution mediation has been advocated consistently in the last few years, however, with the objective of allowing parties to expedite dispute resolution through an out-of-court settlement. Pre-institution mediation, this is one of the judgments I was talking about, 2021 Patent Automation. Pre-institution mediation was made mandatory by the Honorable Supreme Court under Section 20 of the Act, and it was laid down in the case of Patent Automation versus Rakeja Engineers, which is an SLP that was filed in 2021. So the text of Section 12 is provided there if anyone is interested and wants to read. Okay, so pecuniary jurisdiction for filing commercial suit, as I was saying, in Telangana it still remains 1 crore because the amendment hasn't been notified. So whereas in other states the act has already changed the pecuniary jurisdiction to 3 lakhs. So for example, in Maharashtra also it is 3 lakhs, in Andhra Pradesh it's 3 lakhs, in Karnataka it's 3 lakhs. In a lot of other states where the amendment has been notified, it's 3 lakhs. Now, the procedure filing and limitation period, I think you've already seen this, but again, we'll just quickly browse through this. Mandatory pre-institution is there for a commercial dispute under Section 12A. Filing the commercial suit, you file your claim, then there is a written statement that has to be filed within 120 days. Disclosure, discovery, and inspection of documents. This is very important. Now, along with the leave of the court, deliver integrities in writing for the examination of opposite party, the plaintiff must find a full list of photocopies of documents that are in power, possession, and control or custody related to the suit. Now, what this means is that when you're filing a suit, or if you are the petitioner filing a suit before the commercial court, you have to, along with your plaint, file a list of all of the documents. So you would have seen this in some of the pleadings that you all would have filed. A list of an index or a list of all the documents that is being filed, along with the photocopy of all of the documents that is being provided to the other party. So most times the court would insist on copies being served to the other party before they admit the plaint and before they direct the other party to file a written statement. Now, along with the written statement, the defendant must similarly file a list of all photocopies of the documents that he is referring to, and he also has to share a copy of the same with the petitioner. Now, either the plaintiff or the defendant should decide the application for leave to deliver interrogatories. Now, interrogatories are nothing but the questions that each party may ask the other during the cross examination. So, let's say if the matter is at the stage of evidence and the parties are about to cross examine each other's witnesses. The questions that would be posed to the other party are known as interrogatories. Right, so these are also typically, as the practice, exchanged between the parties before the evidence hearing. Case law hearing within 4 weeks of filing the affidavits and of admission or denial. So there is something called as an affidavit of admission or denial. So basically, each party has to admit or deny the documents that are filed by the counterparty. So let's say if you are the petitioner and the defendant has filed certain documents, you have the option to admit to those documents or deny those documents, right? So you have to file an affidavit admitting or denying those documents, and similarly, the defendant does that for documents filed by you as well. So judgment, again, within 90 days of conclusion of the arguments, judgment has to be passed. And then, of course, appeal provision as well, 60 days from the date of judgment. Now, this is the procedure, filing an application period under the CPC. So filing a plaint within 30 days, plaintiff can withdraw the plaint within this time. If after submitting the plaint, the court finds that it should be submitted before some other court, the plaint could be returned and intimation thereof is given to the plaintiff. Service of summons. Within 30 days, defendant can file a written statement within this time. To expedite the filing of reply adjudication of claim, the court may direct filing of a written statement on the date of appearance and issue suitable summons for that purpose. So sometimes the court will either on the first date of hearing give you time to file a written statement, or the court may in that summons say that you have to appear on so and so date along with your written statement. In case there is an urgency, then you have to appear on that date along with the written statement and file the same. Appearance of parties again within 30 days. When neither the plaintiff nor the defendant appears, the court may dismiss the suit. Such dismissal does not bar a fresh suit in respect of the same cause of action. So generally, if a suit is dismissed on merits, you cannot find the same suit again on the same cause of action. Does anybody know what exactly? No, double jeopardy is for criminal matters. This is res judicata. So, double jeopardy is for a criminal matter where if you're convicted of an offense, you cannot be convicted for the same offense. That is Article 26 clause 2 of the Constitution. But, just give me 1 second. Yeah, so basically, res judicata says that the same cause of action you cannot file in Section 9 CPC. if I'm not wrong. Okay, so appearance of the parties we covered a written statement. Order 8 of the CPC provides that within 30 days, a defendant can file a written statement denying the plaintiff's claim. Then again, you have a settlement procedure. Section 89, if I'm not wrong, the CPC provides for a mutual settlement if the parties reach the same. Interlocutory proceedings. These are proceedings that are taken up by the court during the course of the suit to decide some interim matter, such as the grant of an injunction or the appointment of a receiver. So all of you would have heard of the concept of an interim application, IA, under the CPC, right? So this is the provision that deals with that. Typically, Section 151 of the CPC deals with your provision for filing IAs. So whenever you file an IA, it is filed along with a particular provision or order or rule read with Section 151. Production of documents. Parties are required to produce all the documents that are relevant to the case. Again, pretty standard and self-explanatory. Examination of the parties. Now, parties are examined by the court to elicit their evidence. Now, essentially, when parties are reading their evidence, it is called examination of the parties. And then when the parties are questioning each other on the evidence read, that's called cross-examination. Similarly, discovery and inspection. Parties are allowed to inspect each other's documents and ask questions about them. This again comes in the cross-examination stage. And then finally comes admission, which is parties can admit facts that are not in disputes, and either party may call upon the other party to admit within 7 days from the date of service of the notice any document that is saving all of the exceptions. Framing of issues, again, very similar to the Commercial Courts Act, there is a provision for framing of issues under Order 14, where the court frames issues that are to be decided in a particular case. Then you have summoning and attendance of witnesses. So the court also has, the civil court and the CPC has the power on a particular date to summon witnesses to the court if it feels those witnesses are important for the disposal of the case. Hearing of suit and examination of witnesses, the court hears the evidence of the parties and their witnesses, and then it examines the same arguments. As soon as the evidence of both sides is complete, one of the final stages in any suit is that arguments of both sides are advanced, and the court hears both sides' arguments. Finally, upon hearing the arguments, the court will then pronounce its judgment, and after considering the evidence and arguments of the parties, the court will pass its judgment. Then, of course, you have the provision for appeal, review, and revision. All of these are three separate things and go before different courts. And finally is the execution of decree. So in the civil court, in the CPC, the final award that you get is called a decree. There is a decree in the favor of the party in whose favor the decree is awarded. That party is usually called as the decree holder, and the other party against whom the decree is issued is called the judgment debtor. So key differences, again, this is a tabular format between the CPC and Commercial Courts Act. For some, there are corresponding provisions. For some, there are no corresponding provisions. For example, under CPC, there is no corresponding provision for pre-institution mediation. Case management also, you see there is no corresponding provision under the CPC. Again, I'll share this with you. You will have this tabular representation. For a lot of provisions, the corresponding provisions are there in the Commercial Code. Now, these are some of the interesting judgments on these topics that deal with the interplay between CPC and Commercial Codes Act. If you're interested, you guys may go through these judgments. The Supreme Court of India, in the judgment of Kandla Export Corporation, has discussed the statement of objects and reasons for Act 2013, which includes, amongst other objectives, the amendment of provisions of the CPC and prescribing a minimum pecuniary jurisdiction for commercial courts in order to improve the efficiency. So whether the Commercial Courts Act had the power to override the CPC in terms of pecuniary jurisdiction for commercial courts, that aspect was discussed in this judgment. And of course, it is the need of the hour that commercial disputes be decided by commercial courts by following a special mechanism for their disposal. This is in conclusion to whatever we've seen now. We can safely conclude that for commercial courts, it's essential that the courts have a mechanism that is specifically designed for these disputes and have courts that are designated for this purpose. Right? It's important from the ease of doing business perspective and also from the perspective of companies which have a high number of disputes going on. To help them resolve those disputes quickly, you need to have these courts in place. Otherwise, uh, the regular civil courts would just be clogged with more and more disputes. So the precision and focus that is sought to be introduced by the Act of 2015 is also to establish a judicial dispute resolution mechanism that is not only fast, but it is not mired in procedural delays and loopholes, right? Which is essentially, I think, what one of you was asking about the procedures. So, of course, the procedures are important, but at the same time, the Act wants to ensure that there are no delays because of the procedure, and that generally, along with adhering to the procedure, the timelines are adhered to as well. I think so. That's it. I think from my end in terms of both the presentations, but be happy to take any questions. Yes.
Hello, Mr. Rajiv. I'm Vanshika Aman. I am also a student, coincidentally in the same class as Piyush attended. And I think we're ganging up on you today. My question is twofold. First, that there was a discussion in Section 12 on pre-institutional mediation. My question stems from the fact that what it mandates is the court appointing a mediation procedure, the DSLA playing the role there. What if two parties already decided their mediation procedure, have a pre-appointed mediator, want to go with that mediator forward? And then the DSLA comes in, well, how does the conflict play out there between the institution and the party autonomy? And second is there on the slide, somewhere on the slide, there was a mechanism where there was a direct appeal to the Supreme Court from the district court, the decision of the district court. And there was another mechanism where you go through the original appellate jurisdiction of the High Court and then to the Supreme Court under 136. So under what situation would there be an appeal directly lying from the district court to the Supreme Court? Thank you.
Not sure how audible I am. Can you hear me? Yeah, so thanks for the full question. So the first part with regard to the conflict of institutions, see, typically the mediation provided for under Section 20 is done at the DLS. There isn't any mechanism for an external institution just yet. Courts might maybe get into MOUs with some mediation centers or something like that, which I think is a better move because the DLSs are currently not equipped to handle the inflow of mediation that is happening. And even if the Section 12 mediation were to be successful and if parties are caring and are ready to mediate, the quality of the mediators that are available at the DLS currently, at least I can speak for Hyderabad, is not up to the mark. Right? It's not these mediators are not trained to address commercial disputes. And typically, they would just ask the parties to try and approach a settlement. If it doesn't happen, this is the mediation would fail. But I think what is required is a more holistic approach to this mediation, and definitely institutions other than the DLSA should be encouraged. But as of now, there is no provision for a mediation to be done outside of the DLSA. The mediation that is done under Section 20 of the Act has to be done through the DLSA. The parties can, however, choose to not go into the commercial suit and completely opt for a mediation before a private mediation center or any mediator of their choice. In which case, what they can do is, if at all that mediation eventually fails and they decide, one of the parties decides to file a commercial suit, they can use the order of that mediation or the proceedings of that mediation to seek a waiver under Section 12 of the commercial district court side for filing the commercial. So that is something which courts will take a favorable view because a mediation proceeding has already been conducted. But however, you don't have the option of conducting a private proceeding through a private mediation center. That is the current situation. I think. Maybe hopefully you'll get a situation where courts are engaging, private mediation centers, which might see an improvement in the quality of the mediators that have been appointed to mediate. Now, coming to the second point of when a case can be on appeal directly from district court to Supreme Court, the Supreme Court, it only happens. It only happens in the case of an SLP. So, in the case of a special leave petition, sometimes parties, if they agree with, they feel that that they need immediate relief, they approach the Supreme Court directly instead of going to the High Court. Sometimes there might be a situation where, due to the particular roster, that particular point of law or the judge which hears that particular appeal, that position might be vacant. The High Court might not have a particular judge hearing that particular matter. There might be some other practical difficulties. Sometimes it mostly happens that during vacations, people prefer to directly go to the Supreme Court as opposed to the High Court because of the vacation bench issues. So if there is a point of law which requires that level of urgency, that you need to go directly to the district court or Supreme Court, then the special leave petition under the Constitution provides for that. And in those exceptional circumstances, you're allowed to proceed.
What is more economically beneficial for your client? What would you do?
So it really depends on the situation and what my client really wants. I mean, if it were up to me, I'd ensure that my client doesn't litigate at all. To be very honest, so that's again something that you would, a predicament that you would find yourself in as a litigator. 9 times out of 10, you would advise your client not to litigate. Even I do as well, actively a lot. In fact, as of now, I'm handling more settlement proceedings than litigation proceedings, right? The reason being, at the end of the day, you as a litigator, you as a legal professional, you're looking out for your client, you're looking out for the best interest of your client. And if that can be achieved in a month through a settlement, why would you want to do that in 5 years or 6 years through litigation? Right? That is essentially your goal is to achieve what your client wants, and if you're achieving that through discussion and negotiation, you might as well do that than waste time in court and waste the client's money. But you might know that in most of the civil disputes, including the commercial courts and the regular civil courts, you end up paying hefty court fees. Generally, varies anywhere between 2 to as much as 8% in some states of the value of the dispute. I've seen matters where I was handling a defamation suit for an HNI client in Hyderabad. He was the former CTO of one of the IT companies. He filed a defamation suit with a claim of 5 crore against his company. And the CEO of that company took it so personally that he in turn filed a counterclaim of $5 million and paid a 50 lakh court fee just to file that claim. Right? And in that entire process, the case is pending now. It's not going anywhere. They're trying to mediate. It's still pending. It's been 2 years since it has been filed. We were able to get the interim relief, but after that, nothing happened. Both parties have got interim orders. They engaged the senior counsel, they got an interim relief. They engaged the senior counsel, they got an interim relief. That's it. The lawyers made money, the court registry made money, that's it. And the parties did not get the relief, they're both still stuck, and this person is still not able to get another job. And the company is still embroiled in a litigation where they paid 50 lakhs of court fee to a court and it's just stuck in court for no reason. Right? So a lot of times decisions are taken on the basis of egos and on these kind of things, and it just doesn't make sense to anyone. So if it were up to me, I would have ensured that this litigation did not happen in the first place, and the parties reached some sort of mutual understanding where a certain portion of that 50 lakhs would have been paid to either party, and the entire dispute would have been over, right? But instead of that, they took it on their egos, and they're just now suffering with the dispute.
The next question was very much that are there situations where parties might want to prolong their litigation to the business perspective? Is that
It's very rare that a party would want to prolong a dispute from a business perspective. Very, very rare. Until unless sometimes it's a very strategic move to do so, right? But generally, most times businesses are in a rush to wind up disputes than to prolong them. Sometimes, yeah, sometimes, especially if it's a dispute against the government or if it's a dispute which would, by extension or by existence of that dispute, it would basically compare a situation where other parties are affected and are not able to, act. Like for example, in tender matters, right? if one particular party has filed against a particular government because of that entire tender is on hold and other bidders are also not able to file a tender, then you get to ensure that okay, if I'm not getting the tender, you are also not going to get that tender, right? So from that devilish perspective, you can maybe file that would just to put that entire tender in jeopardy and ensure that nobody is getting benefit of that. Those kind of things. I think those are the only very exceptional situations where not do you benefit and neither do anybody, neither does anybody else. I think those are the few situations. But other than that, generally parties are in a rush to resolve disputes rather than prolong.
Sir, last year there was a mediation act passed, and
Yes.
how would you say that there are any practical implications that you have seen come across? Because as Section 12A mandates mediation, are there any practical implications of the act that you see in your day-to-day practice?
Yeah, it's a very interesting question. Mediation Act was passed last year. However, I think some of the notifications are still pending and the full implementation of the act, if I'm not wrong, is still pending. However, I am very interested to see how that act interplays with Section 12A because I believe that once that act comes, there will be certain changes made to how mediation is done currently in the Section 12A. But one of the, I think, key features of the act is that again, it makes mediation mandatory, which is again, in my personal belief, it's against the very essence of mediation. That mediation has to be a voluntary act. You can't, put a gun on someone's head and say mediate. It doesn't really work that way. But having said that, I think the act does have some positives, and it is definitely looking forward to seeing how it's implemented. And also with setting up of a National Mediation Council and a body that is going to govern mediation across India, that will be interesting to see how that plays out. But I think more than of course, commercial disputes is where mediation can be can be effective. But with commercial disputes, as I said, what happens is oftentimes, or rather more often than not, the decision is taken or the decision making power is decentralized. Right? It's not with one person unless it's a promoter driven company. It's generally with the CEO, CFO, and so many other people and your head leaders and general counsels. With the involvement of so many parties, what happens is, personalities, egos, all these things come into play. So it becomes a very messy procedure. So where I see the Mediation Act and mediation being very successful is family disputes, matters pertaining to custody of children, matters pertaining to divorce. I think it could go a very long way there. Mediation, even in criminal matters where there are a lot of where there are some uh, not very heinous crimes. I think there also mediation. It could be a good alternative to the Lok Adalats currently that we have, where criminal matters are being settled before the Lok Adalats. It could be settled by way of mediation. So I think that is something that I see as something that is good scope for the Mediation Act. In terms of commercials, I think they have to be decided by court because until and unless for a company to have a binding order, they're not going to take it seriously, right? At the end of the day, the order of a mediator is not binding. It's just suggestive to both parties, and that in business is not going to be needed. So feel free to ask more. I have the next 2 days.
I have a follow up on what you mentioned to this question about the fact that there are different personalities involved in a case that you're handling. And that is true for every commercial suit that you might be handling within a company that you're dealing with different officers, different people, different personalities. How do you manage these different people and then decide on one course of action? That is my question.
That's a very interesting question. I think that's the biggest part of our job. Right? I see myself as somebody who manages personalities, somebody who manages people, right? That's, I think, the most important aspect of your job. And if you're not a people's person, I don't think you should be considering this career in the first place, right? At least commercial litigation could be doing something else. But having said that, you really have to have the ability to be able to converse with people. You have to have the ability to be able to listen, to be able to be persuaded, and also the ability to persuade when required. I think that is really important, and it's all the more tricky when it comes to negotiations because, especially settlement negotiations, you're not only negotiating with your party, but you're negotiating with the counterparty and their lawyer, who is as smart or smarter than you most times. So you will have to then handle all kinds of people, and I think it's a very situation to situation thing. I can't give you a a jacketed answer as to how you can deal with it is really something that has to be dealt with on the bounce. But having said that, I think if you have the necessary capabilities and the understanding of your client's case, you can ultimately influence the situation in such a way that you're able to get the best fit. At the end of the day, you have to understand what is your client's takeaway from that particular case. Right? So the way I operate is I always make a list of 5 scenarios that my client would want from a particular case. Right? What is the best case scenario? Would be number one. What is the worst case scenario? Would be number five. And most times we end up at somewhere around number three, right? So I think that is a strategy which really helps me. For every client, I make a list of what the client would expect, and that really helps me when I'm going into negotiations with the other side, with the council, with the parties, where I'm able to put forth, my client's different situations, and generally they're also able to decide on a middle ground and be able to come to consensus. Like, even now, I'm handling a dispute between one of the larger healthcare companies from India, hospital giant, and one of the larger office parks companies, the company that manages various tech parks across various companies. This is a dispute that could, what a point is, could potentially be a 1,200 or 1,400 crore dispute, but they're on the verge of getting a settlement done and essentially saving, although I'm hurting myself in the process of losing the potential billing, but what I'm gaining is the client's trust, right? What I'm gaining is the confidence from the client that I can resolve a 1,200 crore dispute without going to court, right? Which I think goes a much stronger way than any amount of billing that we can make, because once I have this client's trust, that client is going to be with me for the rest of my life.
And the billing call.
Exactly. Which is what happened. I'm not sure how many of you have followed my career, but I'm with Rudraputra now. I joined this firm about 3 months ago. I was earlier with a firm called KSK in Southern Pacific, and I was getting there at the office. And when I moved with my team, it was about 6 members from my team moved with me. But I also moved with the majority of my clients who chose to come with me. It's not like I influenced the clients to work with me, but they chose to follow me to my new firm. I think that's what happens when you focus on building relationships as opposed to building a certain amount of billing or a certain amount of a book. I think that's the difference.
Adding to that, is it always a good idea to be completely honest with your client?
Again, it depends on the situation. Yes, and sometimes you have to again take that part as a person where you need to tell. Like for example, in this defamation suit I was telling you about, there was a scenario when before filing of the counterclaim, the Senate Council they approached us and they told us that they were willing to consider a settlement in this if our client withdrew the suit and paid a certain amount of money. Now that particular proposal would have just infuriated my client even more and would have driven him to file a bunch of other frivolous cases against this company, which would have eventually hurt the chances of settlement or litigation. So I decided not to share that particular information with that client at that point of time. So sometimes you have to take these calls, because at that I was telling you how sensitive that case was. There were egos already at play. That person had already filed, 50 lakh, 5 million USD claim with the 50 lakh court fee. So when the electricity is that high, you have to take a call, right, to do something. And I didn't want to basically put more oil in the fire, so I ensured that that particular information I didn't share with my client. Otherwise, it would have escalated to another. So sometimes you have to take these calls where it's not being dishonest, but it's maybe not being completely honest.
Somewhere in between.
Somewhere, yeah. I mean, at the end of the day, to satisfy your own conscience, you have to draw these lines. And I think, yeah, it's a very situational thing which you have to decide based on situation. Sometimes you could be wrong, but then that's the
Lawyers more psychiatrists.
a bit of everything, right? The psychiatrist or therapist, with everything, especially if you are a lawyer who handles mediation, you also end up playing the role of a therapist, especially if you're handling family disputes and things like that. One of the reasons why I stuck to commercial litigation and not private disputes is because I found myself becoming more of a therapist, especially when I handle divorce matters. A lot of times, these clients also would share their personal problems with you, uh, and expect you to advise on that. And that's really not your place to be talking about as a professional who's giving legal advice. Right? So I think that's a very important distinction, which is why I think commercial litigation is something that I think made sense for me because for the personality that I have, it really suited uh, uh, I guess how do I put it, the outlook of a commercial litigator. It just fit perfectly for me. So I guess to each their own, right? You really have to decide what sort of law suits you. Because I've seen a lot of people exceed really well in family law, I've seen people do really well in labor law. So it really depends on what suits you and what your personality is.
Good afternoon, sir. Sir, I am Shashank. I am a third year law student. Sir, I have a question like what exactly community mediation is and what is the future perspectives of the community mediation in India, sir?
So mediation again is a topic which is again being introduced with the Mediation Act, but uh, it's not something which is very widely popular in India yet. I think it's going to take some time. As I said, the Mediation Act itself is yet to be notified, that's also being taken time. I think it could be a useful tool. It really depends on the type of matters that come forward. Like, for example, interpersonal matters such as family matters or custody matters, which I was giving an example of, could not really be decided under community mediation, but some bigger issues. I think where I really see something like community mediation being effective is when you have these association related issues, like it could be a residents welfare association of a particular apartment, or it could be any cooperative society of a particular group of people. I think in those cases, if that particular group collectively is facing an issue, I think there the concept of community mediation can be helpful. But in general, I mean, I don't see it being too much of a game changer in India, at least as of now.
Good afternoon, sir. I'm Rupali Manjaria. I'm currently in third year. So my question to you is like most of the queries have been taken up by you and most of the curiosities have been settled. But what would be your advice to the young professionals who want to join the corporate litigation field, especially with respect to the skill set that is required in the field, including the soft skills?
It's, I think, frequently asked question more or less about the group, but I think at the end of the day, you as a professional would have to ask yourself what you want in your career, and if you know that you want to pursue your career in litigation. For me, I didn't. I'm not sure how many of you again know my journey. I started off as again most law students with this bug of being a corporate lawyer, doing wanting to do corporate law, and having zero understanding of what corporate law meant at that point in time. It just sounded very fancy, and I wanted to do that. And I started off my career as an in-house counsel. I worked at a company. Very excited to do that, but then very quickly realized that that is not the path that is meant for me, and I wasn't feeling very satisfied or fulfilled that line of work. And that's when I realized that maybe I would be more effective or I would be more useful to my company if I had some more knowledge from the government or had some basic skills. Because as an in-house counsel, the company has some expectations from you, which if you're not able to fulfill and you're not able to advise the company at the company in the right way, then there really is no point. So that's when I decided to, within the first 6 months, pursue the career of the law firm. I joined the general corporate team of doing transactions and assisting with share transfers and things like that. And it was at that firm that I first stumbled upon litigation. One of the partners, co-partner partner of that firm was a litigating partner. As so one day didn't have work or something. I just was working with him on a winding application back then. The IBC and NCLTs still didn't exist. So this was before the company law board and the old company that we were finding up application. And I had drafted that application and went to this particular company. I was very, mesmerized by the work and then met this client who happened to be a corporate client. It sort of really like the way the partner communicated with the client. It really resonated with me, and I really liked that approach. And from there, I enrolled myself as an appearing in the High Court. I was just then High Court of Andhra Pradesh as well. Now, of course, it's High Court of Telangana. So yeah, as I said, I started appearing, and then just like that, I was sucked into the litigation rabbit hole, you can say. And like I said, I consider myself an accident litigator, but then again, it really depends on you and what you want from their career. But I think my only advice to young professionals would be, uh, have that clarity of thought as to what you want to do. But even if you don't, it's okay. You don't have to worry about it. For me, I did in the first 1 year of my career, and I turned out okay. So if I can figure it out, I'm sure you guys can do. And just maybe focus on understanding or just seeing how a particular career decision is impacting you, and just see whether you're happy in that amount, and then based on that you take a call. Because at the end of the day, if you're not satisfied, you're not going to be good at it. There is really no point of pursuing something, even if the money is good, there's no point of pursuing something just for the money. Focus on the satisfaction and the money will come.
Thank you, sir. I would like to invite our faculty chairperson, Dr. Praveen Kumar sir, for giving a vote of thanks to our guest lecturer.
So, very good afternoon to all of you. First of all, thank you very much. On behalf of our Vice Chancellor in absentia, Professor Preeti Saxena, and the university, and our faculty colleagues on PAC, and on behalf of this group of students, this is my duty as well as my heartfelt gratitude towards Luthra, and especially Rajiv sir. Thank you very much for sharing your valuable insights on certain laws and the practical aspects of the laws, how you practice as a firm, as an individual in different courts of law. We here at PAC, we have just tried to showcase the single cross section of our students to your firm, and I hope you would love to engage and provide us the opportunity to maintain this relationship and to take this from cross sectional to longitudinal one. Again, on behalf of everyone, heartfelt thanks. Thank you very much. We would love to host you again and again. And thank you very much. Thank you.
I now request all to stand for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल वंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे